This is Jasmine Tohidi, and this week I'm going to do a brief video regarding the fiance visa petition process, also known as a K-1 visa. So what is a fiance visa? A fiance visa is filed on behalf of your fiance and another spouse to bring them to the United States so you can get married and then file for a green card on their behalf. So who can submit it? Well, only a U.S. citizen can submit a fiance visa on behalf of their intended spouse. So if you're a green card holder, you cannot go through that process. You must actually get married to petition for that individual. The K-1 visa would include your intended spouse's children based on one petition that you would list there. So how does it get done and what do you need to do? Well, first you have to have met your fiance in person within the last 2 years before filing the I-129F, which is the petition for a K-1 visa. So how do you prove that? Usually I submit a copy of my client's U.S. passport with a stamp in it showing that they've gone and met them. There are limited exceptions, however, they're very difficult to obtain, so I usually don't tell my clients to go that route. After you do show that proof, you must then show that your relationship with the individual is legitimate. So communications, different things that the two of you have done to show you've kept in contact and that you're in a genuine relationship. Now, if you went through a marriage broker, there's very different rules. I don't handle those kinds of cases. If you have a conviction for certain domestic violence or sexual violence crimes, you also may be barred from applying for a fiance visa on behalf of your fiance. So if you do have criminal history as a U.S. citizen, you should probably consult with an immigration attorney to make sure that you're eligible. So you submit the I-129F with the evidence that I stated, and it's also listed on USCIS's website about what's required. So if your I-129F or your K-1 petition is approved, you'll get an approval notice telling you that your case will be forwarded to the U.S. Embassy where your fiance lives. The case is actually only valid for a period of 120 days, but you can ask the embassy to extend the validity period. So once your case goes to the U.S. Embassy, they will contact you for the next steps. Sometimes they forget, so you can contact them for the next steps. But the most simple part is you fill out a non-immigrant visa application. That's called a DS-160 on behalf of your fiance and their child if they're bringing them with them, as well as the requested documents from the U.S. Embassy. And you also will have to do a medical examination before going to the interview. So once they issue you the visa will have a validity date on it. That means you have to enter the United States before the visa expires. Once you're in the United States, just like the TV show, you have 90 days to get married. If you get married within the 90 days and file for the green card, you don't have to submit any extra documentation. However, if you do not get married within the 90-day period, but you do get married afterwards, you can still file a green card for your now spouse, but you have to submit a Form I-130 plus the green card application, meaning you spend extra money. So if you can avoid it, make sure you get married within the 90 days. If everything falls apart, your intended fiance can depart the United States before your marriage without consequence. If you have any questions about applying for a fiance visa, you can call my office for consultation. I do charge a fee. Our office number is 202-656-6571. And again, like I always say, if you're doing it on your own, read the instructions, read the instructions, read the instructions, and the checklist of required documentation. I hope you have an excellent weekend. Thank you.